everyone. I'm Andreas Televantos. I'd like to start by thanking my kind hosts for inviting me here to the Central European Academy. And as you've heard, I'm going to talk about trusts, which is a legal institution which developed in England, but has spread through the common law world and beyond for the holding of property. And building on, and now we're told, of course, in the conference program that the basic aim of the conference is to look at possible historical models for preserving the unity of family, business, and agricultural assets, and how those historical models might be used today. What I'm going to be doing in this talk is looking at an example of this phenomenon in real life. I'm going to look at historical examples of trusts of businesses being used in England to preserve business assets for a family. And then I'm going to look at how modern lawyers throughout the Commonwealth have used this structure to preserve business assets together. But I'm ultimately going to be asking, is this a good thing or not? Because the effects on creditors of the use of the institution in this way can be problematic, I think. Now, my talk is going to have three main parts. I'm going to start by explaining and outline what a trust is, and I'll hope you forgive me. I've often struggled to do this in civilian contexts, simply because the English is so weird and idiosyncratic in their legal institutions, maybe a bit less internationalist than others. The second part, it will be the most historical part. I'm going to talk about trusts of businesses in England in the 18th and 19th centuries as created in wills. Finally, I'm going to move on to look at how lawyers today have taken inspiration from this historical model to create trading trusts of family businesses, which are particularly popular in jurisdictions like Australia. I'm going to explain all this more as I go on. What then is a trust? Well, at its most simple, a trust is a legal institution from the holding of property, which is distinct from both company law on the one hand and agency law on the other. It functions as a way of dividing up the typical incidents of ownership in a manner that is not possible in most legal systems that do not recognize trusts. And it does so without the need for either registration or extensive formalities. Now, I think one of the easiest ways of understanding what trusts are is to look at the matter historically. And historically, trusts evolved out of the division in England between courts of law and courts in equity. There were two parallel sets of legal institutions. Some English commentators have drawn a distinction with the old Roman law distinction between the equity exercised by the praetor and the rules allowed by the normal forms of action. And the bottom line is this. Courts of equity would order so on the left of the slide, you'll see we've got a picture of the medieval courts of common law, which were the courts that first evolved to exercise the king's justice. And that picture is of the Court of Common Pleas. However, an ad hoc jurisdiction evolved whereby the sovereign, in exercise of prerogative rights, would grant petitioners relief in cases where the common law courts would not give redress. And the exercise of this jurisdiction eventually hardened into a separate set of courts, which became to be known as courts of equity. And preeminent amongst these was the Court of Chancery, pictured in its 18th century form on the other side of the slide. Now, one aspect of the jurisdiction of the Court of Chancery involved controlling how the rights recognized by the common law courts were used by the people who held those rights. For instance, in cases of fraud, a person with legal rights might be ordered to transfer their rights to another or be restrained from exercising their legal rights in particular ways on penalty of imprisonment. Likewise, if someone who held legal rights declared that they held those legal rights for the use or the benefit of another, I think ad opus in the earliest medieval sources, courts of equity would recognize this beneficiary of the trust or the use as having rights against both the trustee and in respect of the subject matter of the trust. Now, that's hard, I think, to grasp in the abstract. I'm hoping the example as on the slide will make things a little bit easier. Let's imagine that A holds the legal right to the ownership of a farmland, and he declares a trust over that farmland in favor of B, the beneficiary. Who has what rights in this case? Well, the split we get is one that isn't, I think, intuitive to someone coming from a civilian mindset. So on these facts, A here, the trustee, has the legal title to the farmland. That is to say, the rights to the farmland that were historically recognised by the courts of common law. Crucially, this includes the right to possess the farmland. And today, it is A who would be registered as the owner of the farmland in the National Land Registry. And if a trespasser enters the farmland, it is A, the trustee, not B, the beneficiary, who must bring the claim to eject the trespasser. So if you have right ownership of land, and you have the right to possess the land, declaring a trust over the land does not change that fact. What then does the declaration of trust do? What rights does B, the beneficiary, have? Well, as a beneficiary of a trust, B is said to have equitable title to the farmland, rights that were historically recognised by the courts of equity. And today this means the following. First, if A, the trustee, fails to properly administer the trust according to the terms on which he's declared it, then B will have claims against A for breach of trust. Now, that's not very surprising. That just sounds like an agency or a contractual relationship. But trusts go beyond that because the beneficiary of the trust does not merely have personal obligational rights as against the trustee, they also have proprietary rights in the following way. For instance, if A, without authority under the trust's terms, transfers the farmland to a third party, then B, the beneficiary, can bring what is known as an equitable proprietary claim to recover that farmland and have it either transferred into his own name or into the name of a new trustee. And the Oxford jurist Peter Birks described this as the closest English law ever came to a vindicatio, the vindicatio of Roman law. Finally, and for our purposes most significantly, the farmland, because it's held on trust for B, is not available to A's creditors if, for instance, A becomes bankrupt. Although A has legal title to the farmland, even if A does not pay his debts, his creditors cannot levy execution against the farmland. Historically, Chancery would issue an order to prevent creditors doing this. Today, a court will simply refuse to make an order in the first place, authorising the creditors of a trustee to levy execution against property held on trust. Further, if A, the trustee, becomes bankrupt, the farmland will not vest in his bankrupt estate, and so it cannot be sold to meet his debts. We turn now to historical uses of trusts of family businesses, examining cases of what I've called testamentary trading trusts, drawing on my historical work in my monograph, Capitalism Before Corporations. And the picture on the slide is of the court record of the case ex parte Garland. That case involved a testamentary trading trust, and as we'll see, still shapes English law today, and I'll return to it shortly. I'm going to begin, though, most basically. What is a testamentary trading trust? Well, imagine we're in 1800 and a husband and wife run a business together that support their family. They have no substantial assets outside the business, and they have an infant son who they hope will one day take over the business when he grows up. The father is drafting his will and wants to make sure that the business can keep on operating after his death, even if he dies while his son is still a child. He wants his son to be able to take over the business and carry on using the profits to maintain the family, younger children and the widow. A complicating factor is that the business is unincorporated. As the English jurist Frederick William Maitland recognised, Maitland was very interested in German law, English law, compared to civilian systems, did not, before statute, recognise the idea of a corporation. Instead, English lawyers had the trust. And you could only incorporate a business in England from the middle of the 19th century generally. Otherwise, you needed an Act of Parliament, and these were only usually given to overseas trading companies like the East India Company, or for public infrastructure projects, such as the building of railways or the navigating of canals. A family business then, until the middle of the 19th century, could not function as a corporation. What structure then could a business owner use to try and make sure that after he died, his business might continue such that his son would be able to take it over? Well, the most obvious solution would have involved a trust, and I've set out the typical structure of such a trust on the slide. and I've reconstructed what this structure is, mainly from cases in the court record, though there are some reported cases of this kind. First, in his will, the business owner would appoint trustees to hold legal title to the assets of the business for the benefit of his testamentary estate. And these trustees are usually family, friends, or relatives. Next, the business owner would provide who was to run the business until his son reached 21 years of age. The business would sometimes be run by the trustees themselves, who held the legal title to the business assets, but in other cases, the testator would appoint someone else to carry on the business, either a third-party manager or sometimes his widow. Thirdly, the wills in these cases all provide that until the eldest son reaches 21, or sometimes 25, the profits of the business are to be used to discharge pre-existing trade debts and provide for the family. Fourthly, the wills provided that upon reaching 21, the son was to have the option to purchase the trade assets from the trustees, typically on credit. Finally, the purchase price of the business was to be used to provide dowries for daughters and make provision for younger sons. Now, this structure offered business owners a number of advantages. The first is control. The business owner, so long as he could find a willing trustee, was able to keep the business trading as a going concern after his death, and even exert control over how the business was run by putting it into the terms of the trust, what the continuing family members or relatives were allowed to do with the business assets. The second is that the structure allowed provision to be made for a range of family members. Where a business was the family's major source of wealth, the business could be charged with the payment of sums to maintain the widow and other family members. Just as large aristocratic families had structures using trusts to keep the land together and in the family and providing for all family members, this seems to have been the small business owner's equivalent. Thirdly, the structure here allowed flexibility. The trustees chosen by the testator could be given discretions to wind up or sell the business. For instance, if the family needed money, if there was a market crash, or if the trustees thought that the business owner's children were not fit to run the business. The trustees could be given a discretion simply to sell the assets and split the money between the family members. Fourthly, the trust structure protected the family from creditor claims. Such trusts, crucially, effectively allowed a form of limited liability trading long before English law recognized limited liability corporations. That point needs some explaining. And the explanation is easiest to understand by reference to the case I referenced earlier, Ex parte Garland, decided by Lord Chancellor Eldon in 1804. And I've put the basic facts on the slide. So, Henry Bullman owned a farm and a mill, and he created a trust of the business in his will. He appointed trustees to hold legal title to the business assets and appointed his wife as a manager to run the business, allowing her to take £600 from his other assets for use in business purposes. Now, Henry Bullman died, and his widow ran the business until she was declared bankrupt, having used more than £2,000 of the estate in the business, much more than she was allowed to by the original terms of the will. Now, the surviving trustees of the business argued that the trade creditors should be allowed to be paid from Henry Bullman's remaining non-business assets. And the argument was something like this. The business has been run for the benefit of Henry Bullman, the business owner's testamentary estate, in effect for his family. They were to take all the profits of the business. Therefore, if the business has debts, the testamentary estate should also have to pay the business's debts. The background principle was that in England at the time, if you took the profits of a business, you were deemed to be a partner in the business and so fully liable for the debts of the business. And so the argument was made that any legacies that had been paid out under Henry Bullman's will should be refunded and then used to pay the unpaid creditors of the business which the widow had run into the ground. Now, Lord Chancellor Eldon rejected this argument and said the creditors had no claim, and his reasoning was as follows. The business creditors, on the facts of the case, had dealt with the widow, and so their rights to Henry Bullman's estate were limited to her rights. Next, the will expressly limited the widow to claiming £600 from the testamentary estate for the use in the business. And again, she'd taken £2,000. And as the widow had taken more than she was allowed to, she had no claim in respect of the estate in respect of the business. And the creditors could be in no better position than the widow was, and so had no claim against the estate, even though the estate had benefited from the business. Now, in this sense, these historical trading trusts offered one particularly notable advantage to the family. It allowed a form of limited liability trading before English law generally recognised corporations and before limited liability was recognised in English law. I now move on to the third and final part of my talk, looking at trusts of businesses today which continue to be shaped by the law of the 19th century. And the basic structure of what I've called modern trading trusts are as follows, and I've taken this structure from Nunzio D'Angelo's book on commercial trusts. So modern lawyers, taking inspiration from history, have done the following. You have a family business, and in some jurisdictions, for reasons I'll come on to, there is a desire to run that business through a trust. The following structure is usually adopted. First, the business owners create a limited liability corporation to act as a trustee. Secondly, the business assets are transferred to the corporation, which holds all the assets on discretionary trust for family members. That's important because despite the use of the corporate form here, it is the family members who are meant to profit from the business that beneficially own the assets of the business. The corporation just has the legal title to them. Thirdly, the terms of the trust allow the corporation to trade with the assets and incur liability for the purposes of the business. Finally, the corporate trustee has no other assets except for trust assets, and so holds no property for its own benefit. That's partly why these structures have been criticised. You've got a corporation that holds no property for its own benefit, incurring liabilities, protecting the family from the liabilities if they protecting the family from the liabilities of the trade, but giving the assets of the trade to the family. And we'll see how that can cause problems for creditors very shortly. But first, what are the advantages of this structure today? Why on earth would you make the corporation, which runs the family business, hold the assets on trust, rather than just make the family members shareholders who receive the profits as dividends? Well, there are advantages, but what they are precisely varies by jurisdiction. In Australia, where trading trusts are very common, especially for small businesses, the main motivation for this kind of structure is tax. Shortly put, in some jurisdictions, paying family members the profits of the business as beneficiaries of a trust is more tax efficient as far as income tax is concerned than paying them dividends as shareholders. And that's a major motivation. There are other potential advantages too, though. Structuring a family business as a trust can involve fewer regulatory requirements than doing so purely as a company, because trusts, after all, have no need to register or file accounts. Finally, as we saw with historical trading trusts, a trust structure can provide protection from creditors. In particular, a modern trust structure can protect even business assets from the business creditors in cases of mismanagement, in a way that corporate law does not. Now, this requires some explanation, and we'll see the relevant principles in this area developed in cases like Ex parte Garland that continue to apply even today. The first point is this, and I'm afraid this gets quite technical. As I said right at the start of the talk, the creditors of a trustee cannot claim trust assets, and this is a rule that dates back to the 17th century, the case of Medley and Martin, which is on the slide. Now, this principle includes business creditors. So where a business is held on trust, as a matter of law, the creditors of the business are simply the personal creditors of the trustee. As such, if they are unpaid, they have no right to claim the business assets, because the business assets are trust assets. The underlying point is that the trust itself has no legal personality and it cannot hold liabilities independently of the trustee. In civilian terms, a trust does not truly involve a separate patrimony. However, a trustee who incurs liability with authority under the terms of the trust acquires a right to be indemnified from the trust assets, which is a point ex parte Garland makes clear. This means either that the trustee can use trust assets directly to pay the trust debts, or, if the trustee pays the debts from his own beneficially held property, he can be reimbursed from the trust assets. Now, this indemnity is important not only for the trustee, but for trust creditors too. Trust creditors can claim trust assets by taking the benefit of a trustee's right of indemnity, so long as the liability is incurred with authority under the terms of the trust. In other words, the trust creditors can indirectly claim trust assets through a trustee's right of indemnity. And English lawyers call this indirect claim a form of subrogation, though that, of course, has a different meaning to civil lawyers. There are, however, severe limits on this mechanism. There are severe limits on the extent to which a creditor of a trustee can claim trust assets. First, trust creditors cannot claim trust assets where the liability was incurred without authority under the terms of the trust, even if the trustee appeared to have authority to enter into the transaction. So if the terms of the trust says the trustee is allowed to borrow £1,000 and they borrow £2,000, under no circumstances can the creditor claim more than £1,000 from the trust assets. The underlying point is that the trustee is not an agent of the beneficiaries, so there is no doctrine of apparent or ostensible authority that exists to protect the creditors. I suppose in Romanist terms, you wouldn't say the trustee was either a mandatory or a procurator in respect of the beneficiaries, and this gives creditors less protection. Secondly, and perhaps more troublingly, a creditor might be unable to claim trust assets even when the creditor's claim is authorised by the terms of the trust. Where a trustee has committed an unrelated breach of trust and incurs liabilities to the beneficiaries in respect of that breach, any indemnity the trustee is entitled to is set off against the trustee's liability for breach, and so potentially extinguished altogether. And where the trustee's indemnity is destroyed in this way, the creditors may be left without any recourse to the trust assets whatsoever. The point is discussed recently by Lord Hodge's judgment in the Privy Council case of Investec and Glenelg Properties. And I'm running a little low on time, so I won't go through it in full, but Lord Hodge essentially emphasises that there is a problem with a case where a creditor lends money to a trustee. That loan is authorised by the terms of the trust, but it turns out that the trustee had been stealing trust assets on the side. The creditor had no way of knowing this, no way of finding out, but that fact in and of itself can prevent the trust creditors accessing the trust assets. And that looks problematic. Now, Lord Hodge ultimately says it's not too much of a problem, because if a creditor is really worried, he can bargain for security over the trust assets and prevent this from happening, but not all creditors will be able to do this, particularly, for instance, if it's a creditor in tort or unjust enrichment rather than in contract. There's one further problem. There is real uncertainty over what happens if a corporate trustee of a business becomes insolvent. The basic rule, as we said before, is that the creditors of a trustee cannot claim the trust assets, and if the trustee becomes bankrupt, the assets don't vest in the trustee's insolvent estate. That prima facie means that insolvency rules the normal insolvency distribution does not apply to an insolvent trustee. And that can create real difficulties, and there's a conflict between the Australian position and what the English textbooks are saying. To conclude then, you can use a trust to hold business assets for the benefit of family members and to keep those assets together, which is of course the theme of the conference. The question though is whether this is a good thing, because the way it keeps those assets together is to frustrate what seem to be legitimate creditor expectations. Thank you very much.